Many of today's most heated political debates involve fundamentally different views of the role of the United States Constitution. And those different views aren't new. They reflect disagreements that go back to the earliest days of the United States of America. Our next guest examines the history of those disagreements in a book titled Our Republican Constitution: Securing the Liberty and Sovereignty of We the People. The author of that book is Randy Barnett, professor of constitutional law at the Georgetown University Law Center and director of the Georgetown Center for the Constitution. Thanks for joining us.
Oh, it's great to be here.
So we all know that we're very politically divided in the United States. Your book, Our Republican Constitution, says it shouldn't surprise anyone who's looked at the history and sees these long-standing debates about how our government should be run, including what the Constitution means. Were you surprised to see how divisive things have become in recent years?
No, not at all. I mean, I think not only are we divided as a people amongst the two conceptions of the Constitution I describe in my book, the Republican conception and the Democratic conception, but most people are actually divided within themselves about this. That is, most people carry around within them a Democratic conception of the Constitution and an inconsistent Republican conception of the Constitution. They tend to favor one when it comes out for them one way, and they favor the other when it comes the other way. So we can talk about what that is, and hopefully if I describe these things accurately, I'll describe what your listeners and viewers recognize about themselves.
Yeah, let's talk about those. So two fundamentally different conceptions. What are they?
Right. They're based on two different notions of popular sovereignty, which is the idea that it's we the people who are the sovereign. And these are two different notions of popular sovereignty based on two different conceptions of we the people. If you view we the people as a group, and then you say what popular sovereignty means is that we the people as a group are entitled to rule, then the only thing that could possibly mean is that a majority is entitled to rule. Rule according to the people's will must be the will of the majority, because you can't have rule by everybody. And then what we need is a constitution, a democratic constitution, that will provide the structure by which the will of the people will be expressed, oftentimes in the form of representation, representative legislatures. And in fact, legislatures could be thought to represent the will of we the people on a microcosm basis. And so we need a democratic constitution to represent the will of we the people. And if you have that view, then the role of judges in such a regime is kind of problematic, because judges are not elected and they don't represent the will of the people. They're not supposed to. And so here's the idea that judges should not get in the way, if they can possibly help it, of the will of the Democratic majority. That's the Democratic conception of of the Constitution, based on a collective view of we the people.
And now, there's an individual view as well.
Right. Well, I mean, if once I've said this, somebody in the audience is likely to say, well, of course that's right. What else could there be? And now I'm going to describe the other one, and I predict that your listener is going to say, oh, yeah, well, I guess I think that too. And the other one is the individual view of we the people. It still starts with popular sovereignty, but it views we the people as individuals, each of whom are endowed by their Creator with certain unalienable rights. Among those are life, liberty, and the pursuit of happiness. That may sound familiar to your audience. All those rights, by the way, are individual rights. The right to life, liberty, and the pursuit of happiness each belong to the individual. And then the book focuses on the next sentence of the Declaration of Independence, which says, to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. So, first come rights, and then comes government to secure these rights. This vision of government is a government as the servants of the people. We hire the government is not us. They don't necessarily represent our will any more than the garbage people that we pay to come collect our garbage reflects us and our will, except our will that we want the garbage gone. We delegate the responsibility of disposing of our trash to a subset of us, and government is a subset of us. They are what we might call the agents, or how's this, the servants of we the people. There's no archaic way of looking at government. They're the servants of we the people, and they're tasked with a job, accomplish certain beneficial public ends, but first and foremost, secure the rights retained by the people. That's what the Declaration tells us. Now, if you take this view, what we need a constitution for, a Republican constitution, is on the one hand to empower the government to do what it needs to do, but on the other hand to constrain its power so it doesn't violate the rights that it's been created to secure, which is the individual rights of each and every one of us. Under this view of the Constitution, judges fit in quite nicely because judges themselves are agents or servants of the people, and they have a job to do. And their job is to be a fair and impartial magistrate when a member of the sovereign public, us, we the people, an individual, comes into conflict with one of their agents or servants. A judge is supposed to be an independent tribunal of justice in order to adjudicate fairly a dispute that the citizen has that says, you and the government, you've exceeded your just powers in the words of the Declaration, and the judge should be neutral. And so the fact that the judge doesn't represent the will of the people is actually a good thing, because we don't want the judges to be biased in favor of one party or the other. That's the Republican Constitution. So here's what ends up happening. When the majority is on your side, people like to assert the will of the people and get mad at judges for getting in the way. Now, when the majority is not on your side, people talk about the tyranny of the majority. And they hope the judges will be there to protect their rights against those tyrannies. So those are the two competing conceptions we carry within us. This book is an argument for why the Republican conception is the right one and the Democratic conception is not.
That is the voice of Randy Barnett, professor of constitutional law at the Georgetown University Law Center, also director of the Georgetown Center for the Constitution. You just mentioned your book argues for the small r, Republican view, rather than the small d, Democratic view. Why do you say the Republican view of the Constitution is the better one?
Because I think the Declaration is right. We start with the rights. I believe that's true. These are individual rights to life, liberty, and the pursuit of happiness. Or the book talks about the fact that James Mason's draft of the Declaration of Rights was actually the more canonical formulation of these rights, which includes, for example, the right of property. And government is are correctly viewed as our servants, and so we need a constitution to protect us from our servants, to ensure that they don't exceed their proper powers. And so that's what we need judges for. I think that's right. And the reason I wrote the book is because, as I describe in the book, I was involved in the challenge to Obamacare. I'm the one that formulated the argument for why the individual insurance mandate is right. And you normally, if you win on the law, you win in the case. And we actually got 5 votes for our view that the individual insurance mandate was correct. And yet, as some of you may know, we lost in the sense that John Roberts, who agreed with us about the law, said nevertheless he was going to uphold the law. Well, how did he do that? He did that by reinterpreting the mandate so that it wasn't a mandate, and then he could uphold the law. He called that a saving construction. And the reason he justified that, the way he justified that is by saying he had to defer to the Democratic majoritarian Congress to do that, which taught me that it's not enough to be right on the law. You also have to be right on the role of judges. And this is a book about the proper role of judges in a republic, which is what we have.
Our time is running short, but if people read this book, what do you hope that they will take away with them as they approach who they're electing, who they want to see as judges? What's the proper response you hope they'll have to this?
Well, when you evaluate a nominee like Neil Gorsuch, whose hearings were last week, you want to ask 2 things about him. One is, does he interpret the Constitution in the right way, which would be to give it its original meaning? And the second is, does he feel that he as a judge has the responsibility and indeed the duty to enforce that meaning against the more majoritarian branches? I think after the hearings last week, I'm cautiously optimistic. I know that Judge Gorsuch is an originalist, so he thinks that's how you should interpret the Constitution, and I'm cautiously optimistic that he will take that he views his role, unlike Chief Justice Roberts, as enforcing that original meaning against the other branches of government.